नमस्ते फ्रेंड, आप सभी का एक बार फिर से वेलकम। और फ्रेंड्स, पेंशनर्स का एक होमोजीनियस क्लास है और अगर उनको कोई बेनिफिट एक्सटेंड करना हो तो हम इस आधार पे कट ऑफ डेट के हिसाब से डिस्क्रिमिनेट नहीं कर सकते। और ऐसी ही एक चर्चा गुवाहाटी हाई कोर्ट के एक जजमेंट आने के बाद हुई और हमारे एक सीनियर साथी ने भी इसके बारे में अपना कमेंट किया है। पहले देखते हैं कि हाई कोर्ट में केस क्या था। स्टेट कैन नॉट आर्बिट्ररली क्लासिफाई पेंशनर ऑफ होमोजीनियस क्लास बेस्ड ऑन कट ऑफ डेट्स फॉर ग्रांटिंग रिवाइज्ड पेंशन बेनिफिट। गुवाहाटी हाई कोर्ट। A division bench of the Guwahati High Court, comprising Justice Ashutosh Kumar and Justice Arun Dev Chaudhary, held that the classification among pensioners based on the date of retirement, when all retirees form a homogeneous class and the pay revision is made effective from the particular date, is arbitrary and unreasonable. Further financial constraints cannot justify such discriminatory treatment. बैकग्राउंड क्या था इस केस का? The Assam Pay Commission 2008 submitted its recommendations for revision of pay and pension. These recommendations were accepted by the government of Assam and implemented with effect from 1st January 2006. However, the state government decided not to grant arrears of pension and death cum retirement gratuity to employees like retired officers, teachers who retired between 1st January 2006 and 31st March 2009, citing financial constraints. Only notional benefits were extended to these employees despite acceptance and implementation of the Assam Pay Commission 2008. Aggrieved by this decision, the respondents filed a writ petition challenging the denial of full benefits under the Assam Pay Commission 2008. The single judge held that all pensioners form a homogeneous class and classification based on the date of retirement for extending pensionary benefits was impermissible, particularly when the recommendations were given effect from 1st January 2006. The state of Assam preferred an appeal against the judgment of single judge but later withdrew the appeal to file a review petition. It was dismissed on the ground that there was no error apparent on the face of the record. Aggrieved by the dismissal of the review petition as well as the original order dated 28 April 2016, the state of Assam filed the intra-court appeal. It was submitted by the appellant that the state has the power to fix a cut-off date for extending pensionary benefits. It was further contended by the state that financial constraints can be a valid ground for fixation of a cut-off date for the grant of the benefit of increased quantum of pay or other benefits. The appellant further submitted that financial constraints constitute a valid and reasonable ground for creating a classification based on a cut-off date, as recognized by the Supreme Court in case of State of Punjab and others versus Amarnath Goel and others. On the other hand, it was submitted by the respondents that the decision of the state to deny area of the pension to those who retired between 1st January 2006 and 31st March 2009 was arbitrary and unconstitutional, as the recommendations of the Assam Pay Commission 2008 were implemented with effect from 1st January 2006. Findings of the court. It was observed by the court that the recommendations of the Assam Pay Commission 2008 was accepted and implemented with effect from 1st January 2006. It was observed by the court that there was no valid justification for creating two classes of pensioners, that is, those who retired between 1st January 2006 and 31st March 2009, and those who retired after 31st March 2009 for the purpose of granting a revised pension. It was further observed that all the pensioners form one class and are entitled to revision of their pension in terms of the recommendation of the Assam Pay Commission. The cases of all Manipur Pensioner Association versus State of Manipur was relied upon by the court, wherein it was held that the classification as sought to be made by the state had no relation with the object and purpose of the grant of the benefit of the revised pension. It was held by the court that the object and purpose of the revision is due to increase in cost of living, and when all the pensioners form a single class, there cannot be any separate classification amongst the homogeneous group. Therefore, the action of the authorities were rightly held by the single judge to be unreasonable, arbitrary, and discriminatory. Further, the case of D.S. Nakara and versus Union of India was also relied upon by the court, wherein it was held that a classification between pre and post cutoff date retirees was arbitrary when both the classes form a homogeneous class. Hence, when all the retirees form one homogeneous class, the benefits must be extended equally. It was also observed by the court that the ratio in state of Punjab versus Amarnath Goel would not be applied to the case. The action of the state was found to be arbitrary and discriminatory. The judgment of a single judge directing extension of revised pension benefits to all retirees was upheld by the court. With the aforesaid observation, the writ appeal filed by the state was dismissed. यानी कि किसी भी कट ऑफ डेट के हिसाब से जो एक होमोजेनियस क्लास पेंशनर का है उसमें आप डिस्क्रिमिनेशन नहीं कर सकते। उनमें जो भी बेनिफिट मिलना हो वो सबको बराबर मिलना है। और इस केस को जो सिंगल बेंच कोर्ट ने आदेश किया था उसको हाई कोर्ट गुवाहाटी ने अपहोल्ड किया। फ्रेंड्स, हमारे जो साथी हैं मिस्टर के सुब्रमण्यम साहब ने इस बारे में अपनी राय रखी है, वो मैं आपको शेयर करता हूं। उनका कहना है, एट अनदर केस इज फेवर ऑफ पेंशनर्स, बैंक पेंशनर्स के बारे में हम बात कर रहे हैं। फ्रॉम दिस जजमेंट आई इन्फर दैट इफ अपडेशन इज डिसाइडेड इन आवर फेवर इट शुड बी गिवन from the date of settlement, that is from 1993, and a later clause cannot be created. Please read the judgment above and tell me whether I am right or wrong. जो जजमेंट के बारे में आपने बताया है उन्होंने उसका जो एक्सर्प्ट लिखा हुआ है, जो उसके बारे में जो समरी उन्होंने बताया है, it was held by the court that the object and purpose of the revision is due to increase in cost of living. And when all the pensioners form a single class, there cannot be any separate classification amongst the homogeneous group. Therefore, the actions of the authorities were rightly held by the single judge to be unreasonable, arbitrary, and discriminatory. Further, the case of D.S. Nakara and others versus Union of India was also relied upon by the court, wherein it was held that the classification between pre and post cut-off date retirees was arbitrary when both the classes formed a homogeneous class. Hence, when all retirees form a homogeneous class, the benefit must be extended equally. It was also observed by the court that the ratio in the state of Punjab versus Amarnath Goel would not apply to the case. The action of the state was found to be arbitrary and discriminatory. The judgment of the single judge directing extension of revision pension benefits to all retirees was upheld by the court. So, आईबी और ईओबी भी बैंक रिटायरीज को डिस्क्रिमिनेट न करे. दे हैव फॉर्म द ए क्लास ग्रुप, होमोजीनियस ग्रुप ऑफ द रिटायरीज. इसलिए जो भी बेनिफिट्स हो टू एक्सटेंड टू द ऑल. थैंक यू फ्रेंड्स. नमस्ते.